Well, welcome back, everybody, to our second panel of the 6th edition of Washington Arbitration Week. We're here at Hughes Hubbard and Hughes Hubbard and Reed in Washington, D.C., of course. It's a real pleasure to see everyone again, and thanks again to Hughes Hubbard for hosting this great session. In international arbitration, there is this quiet competition that goes on between the arbitral seats. We, of course, have the classic and traditional seats of Paris and London and New York, but we've seen a lot of dispersion and uptake of international arbitration in various other corners of the world, whether it's Latin America or the Far East or Southeast Asia, or even Africa. There has been an explosion of arbitral rules and arbitral centers and the use of arbitration for the settlement of disputes. Now, Washington has grown into an arbitration center itself with the headquarters of ICSID, the International Center for the Settlement of Investment Disputes. Here in Washington, D.C., we've developed a fantastic group of practitioners and arbitrators and service providers and experts who service not only those arbitrations, but international commercial arbitrations. But we always like to take a little bit of a look at ourselves and a look at the arbitral seats around the world to get a sense of where we are and where we're going. And we have today James Boykin, who's a partner at Hughes Hubbard and Reed, moderating our first panel. James is co-chair of the International Arbitration Practice Group here in Washington, D.C. His practice focuses on international arbitration and includes not only state-to-state and investor-state arbitration, ISDS, but also commercial disputes. He has worked under all the various rules and has experience with many of the arbitral seats that we're talking about today. So James is particularly well suited for the task ahead. So I want to thank James and thank our panelists, which he'll introduce. And let's kick off our panel, which is titled Choice of Arbitral Seats in the World, What has Changed and Where Does Washington, D.C. stand? So James, away you go.
Thank you. Can everybody hear me? Smart. Okay. Yeah, my name's James Boykin. I'll quickly introduce the panelists here today before so we can get started. To my immediate left is Csaba Rusnak. He's the founder and managing member of Sovereign Arbitration Attorneys here in Washington, D.C., and he was appointed in 2020 to the ICSID list of conciliators. To Csaba's left is Nicolle Kownacki, who's a partner at White & Case. And then we have Simon Consedine, who's a partner at Three Crowns, and before that was at Freshfields. And then we have all the way at the end, Jonathan Ulrich, who's of counsel at Paul Hastings and a graduate of a place very dear to my heart, the University of Virginia. It's the only reason he got the school shout out. Okay, so the choice of a seat for an arbitration. I just want to put to the panel, but starting with Simon. How prevalent is Washington, D.C. as the seat of arbitration? And we heard the title for the panel is Choice of Arbitral Seats in the World, What has Changed and Where Does D.C. stand? Could you maybe tackle that question in terms of what's D.C. and how has that changed?
Thank you. I think the honest answer to that question is not very prevalent as a seat of arbitration. It's necessarily a difficult question to answer because we don't have a complete data set of what seats are being chosen in everybody's arbitration agreements. What we do have is knowledge of the cases that we all work on that do go to arbitration and where are they going to arbitration. And also we have the benefit of some surveys that are conducted across arbitration users. A most recent survey was the Queen Mary White case survey conducted just this year, which asked respondents to advise their 5 most preferred seats of arbitration. And Washington, D.C. came in 14th on that list, and the response rate was 4%. So approximately 1 in 25 respondents identified Washington, D.C. among their top 5. So that's the reality of where we are, at least as far as that survey is concerned. And I have to say that is consistent with my own experience. I predominantly practice in commercial arbitration, makes up about 80% of my work. I have never seen Washington, D.C. as a seat of arbitration in the commercial sphere. So it's consistent with my own experience. I'm not sure if others on the panel have seen the same. A couple of other points just in relation to the what has changed aspect of the panel title. I think we have seen a doubling down on London. I think we have seen a doubling down on Singapore as Hong Kong has slowly started to retreat. And I think we've seen a little retreat on Paris as well. That's what the survey is suggesting to me as compared with prior years. And relevant to this audience and to Jim's first question, the only other American city on the list that made the top 15 is, of course, New York, as you heard in the opening remarks. It's a well-known classic seat of arbitration. And it came up at 13% of respondents identifying it as one of their top 5. So New York being identified at a factor sort of 3 to 4 times more popular than Washington, D.C. So that's where it stands at the moment.
Would the list, and anybody can answer this, but maybe to you in the first instance, I mean, would that list of 15 seats have been different if it had been confined to investment treaty arbitration or state-to-state arbitration? Or does it make a difference whether the arbitration is commercial or investor state when parties choose a seat?
I think the answer is a definite yes, insofar as DC is concerned. It is fair to say DC is not considered currently a leading seat for commercial arbitrations. However, it is a well-known seat in prevalent use for investment arbitration. And of course, we have ICSID arbitrations, which do not have a seat, but DC, of course, remains the physical and spiritual home of those ICSID arbitrations. But it's also true that almost half of investment treaty arbitrations are not ICSID cases, and they do have a seat. And what we are seeing is that DC is a big player as a seat for those cases. Think of cases like Crystal X, Apotex, the UPS in Canada case. These are all cases where DC was chosen as the seat, and often that's a choice that's being made when a dispute has already arisen. The treaty itself does not provide for a specific seat. It has to be decided upon later. And I think one observation I would make is that when the question of choosing a seat is determined by the arbitral tribunal in the absence of agreement by the parties, I think there is a strong preference on behalf of arbitral tribunals to choose Washington, D.C., because the DC courts have a strong record of enforcing investment arbitrations. I'm not aware of an investment arbitration being overturned, on a sort of jurisdictional review or on any of the limited vacator grounds. And I compare that with experience abroad in, say, London, where right now I'm suffering through year 3 of post-award review because the English law provides for de novo review of jurisdiction of investment decisions. And so I am 3 years post the Elliott v. Korea decision, and we're still in the High Court. So if you wanted to avoid that as party and indeed as arbitral tribunal, I think the DC courts are a good option, and that's why you do see it being more prevalent in the investment arbitration context.
Thank you. And that sort of makes a good segue for a question, I have is what do users typically look for when they're choosing a seat? And maybe Nicolle, okay,
because it happened to be covered by the by the same survey that I read in preparation for this, and then I can stop talking and then let everyone else have a shot. But none of this is a surprise. The four things that are identified in the Queen Mary White and Case survey are support for arbitration by the local courts, neutrality and impartiality of the local judiciary, a national arbitration law that empowers that judiciary to provide the support for arbitration as a dispute resolution forum, and a strong enforcement track record. Those are the four things that were most commonly identified by respondents to that survey. And what I think none of that is surprising. None of that would surprise anybody in this room. They're probably the four answers you all would have given too. I think what is surprising is that DC checks all of those boxes comfortably. It's good on all four of those criteria. So it's meeting those criteria and yet still not being identified as a choice of seat for commercial arbitrations despite that. And I wonder if it's a question of being typecast a little bit as an investment arbitration town and New York is the commercial arbitration town. But I think as folks, everyone in this room with a vested interest in DC's success as an arbitration hub, I think we've got to get the word out.
Let's jump on that. And the difference with the investment and the commercial, the investment arbitration involving a foreign state is going to have, default jurisdiction in DC for enforcement as well. It's also going to have federal question jurisdiction because it involves the foreign state and the FSIA. A commercial arbitration between two non-US parties isn't necessarily going to end up in federal court. It has to otherwise, meet subject matter jurisdiction. So DC local courts are great, but they don't have the body of law that New York state courts have. And so two non-US parties, not a foreign state, it would be an odd choice to pick DC for a commercial arbitration because you're basically committing yourself to DC state court for any vacatur. State court.
I think there's a bit of a commercial reality as well. I mean, DC, for all the reasons noted, has a strong record of award enforcement. Courts here are deeply experienced in sovereign immunity issues. We have ICSID here. We have international organizations here. The public law sovereign side of international disputes is something that the DC courts deal with a lot, and probably more so than the New York courts. As a practical matter, I find when advising corporate colleagues and clients on the deal-making side, if they're considering regionally, where in the world are we going to be settling this dispute? And a lot of people still have in mind, okay, if I designate the seat of arbitration, that's physically where I have to go to show up to contest my dispute. From a commercial perspective, a lot of people in New York, the New York deal makers are thinking New York is the place to be for a commercial dispute. So they have sort of a short list of London, New York. And for the reasons noted, DC just not floating to the top of people who are the ones drafting these contracts in the commercial context that are going to specify where the seat of arbitration is going to be.
Quick question, if I might, to my colleagues who do much more commercial arbitration work than I do. To what extent do you see the choice of the arbitral seat lining up with the choice of law governing the contract or the agreement that underlies the parties' business relationship?
Just anecdotally, a pretty high degree of correlation. New York law, New York seat, English law, London. When you get into, you look, of course, you get cases where it's Paris seat, English law, but it's probably in the minority that you see a diversity, in my experience. But that's just mine.
So I'm going to jump just a little ahead and then circle back on the list of questions because I want to key off of something that Simon raised. And it's the issue of courts vacating awards at the seat. And this is something parties rightly should focus on. It's a big difference if your arbitration is seated in The Hague than if it is seated in Geneva in terms of the amount of post-award review process. So I wanted to, Nicolle, you've taken a look at DC and the decisions. When will DC courts vacate an award after the arbitration?
So in DC, Primarily, the case law has focused on the Federal Arbitration Act. There is a DC Arbitration Act, which has grounds for vacatur and tracks many of the same grounds, but those are going to be, that act is very rarely applied, and it's only in cases that are basically contract disputes in DC or employment disputes, like very, very local, two parties here. So otherwise, you're talking about the grounds under the Federal Arbitration Act. And DC courts, like other federal courts around the country, there's just a strong and pro-enforcement bias, I guess, or prevalence of the case law. The standard of review for arbitrators is arbitrations is very deferential. The grounds for vacatur under the Federal Arbitration Act, I'm sure many are familiar, but corruption, fraud, and undue means in the making of the award, evident partiality, arbitrator misconduct, or a lack of due process. And so those procedural grounds, you may not see those in other arbitration acts outside of the United States. So there is a little bit more procedural review in the US, but then the standard is very deferential. We've seen in some of the recent DC, like the DC Circuit, acknowledging that there has to be some sort of undue prejudice to a party from a tribunal excluding particular evidence. It can't just be the evidence was excluded. It has to be, it was excluded, it was very important, and there was some prejudice there. So the courts are adding extra criteria, not just the lack of the tribunal hearing the evidence. And then in the DC courts have hesitated to recognize a public policy exception. The Supreme Court has cast doubt on that. What has happened in the last few cases in DC courts that this has come up about a public policy exception, maybe from fraud and corruption in the underlying contract, the courts will look at that and say, well, there's not even enough to grant on that basis, so we're not going to decide the question of whether fraud or corruption and a public policy exception exists in the FAA. So they avoid the question by just saying there's not enough here to grant vacatur on that basis. And it comes up a lot in the cases because if there is a vacatur petition here in DC, the other party, the prevailing party, is often cross-moving to enforce the award. So under the New York Convention, which I think you're going to talk about a little bit, there's a public policy and fraud defense. So you see that public policy fraud defense come up in vacatur petitions, but it often starts as like a part of a cross petition.
Now, you mentioned the DC Arbitration Act. Is there anything in that act about which parties should be aware? I'm always particularly interested in this because there was a point in time in which the Virginia Arbitration Act gave parties a right to depositions, enumerated, I forget. I think it's been amended to exclude that. But, some people might say that, that's contrary to the purpose of the FAA and therefore, is preempted. Others might say it empowers arbitration and therefore is not preempted. Are there provisions in the DC Act that people choosing the seat should be aware of?
It's largely tracked. The FAA, there isn't, we haven't really seen any significant case law on this. Nothing that significant issue in Virginia that I'm aware of. And maybe it's remarkable, there's hardly any case law at all about the DC Arbitration Act. I think I wrote a practical law guide 10 years ago about how to use it, and I don't think anyone even clicked on that article because no one's using it.
So I think what I'm hearing is this is a plus in favor of DC, that there is not buried in the DC Arbitration Act a right to discovery that one might find in some state laws and about which one could have a spirited argument as to whether discovery is in support of arbitration or contrary to its purpose. All right, then Csaba, circling back to this question, does the choice of DC as the seat offer any advantage to an award creditor if that award creditor is contemplating eventually enforcing the award in the United States? So not necessarily just in DC, but perhaps in another state, Oregon, California, anywhere in the United States as such. Is there something about seating the arbitration in DC that might help respect to enforcement?
Yeah, I think it's a great question. I would say, generally speaking, I can see a few ways in which having the arbitration seated in DC might make enforcement, if not easier, at least a little more streamlined. And let me talk about two ways specifically. One is personal jurisdiction, and the second is merits defenses to enforcement under Article 5 of the New York Convention. I do want to just plant one little flag and say I will also come back to make a comment on set aside, because I think it does cut in both directions a little bit. And so it's not just favoring enforcement, but it can also perhaps bolster set aside arguments as well. So on the first issue, that of personal jurisdiction, to the extent that a showing of personal jurisdiction is necessary in an effort to enforce an award, I do think that having the arbitration seated here in DC would be useful. And the reason I say that is because where the personal jurisdiction analysis is required, you are going to, as an award creditor, need to show minimum contacts between the defendant and the forum. And so having the defendant agree to DC as the seat of arbitration, I think is certainly a helpful arrow to have in your quiver when you're making that argument. As to merits defenses to enforcement under Article 5 of the New York Convention, here I would call attention in particular to two provisions, Article 5.1a and Article 5.2a through b. Article 5.1a, of course, says that enforcement may be refused where the parties to the agreement were under the law applicable to them under some incapacity, or the said agreement is not valid under the law to which the parties have subjected it, or failing any indication thereon, and this is the important part for our purposes, under the law of the country where the award was made. And then Article 5.2a through b says that recognition and enforcement of an award may be refused if the competent authority in the country where recognition and enforcement is sought finds that. And then subsection b, the recognition or enforcement of the award would be contrary to the public policy of that country. And this is what Nicolle alluded to earlier as well. So I could see a situation in which an award creditor comes to the DC courts and asks for enforcement, and the respondent says, hold on a second, I have merits defenses under Article 5 of the New York Convention, and they raise either one or both of these defenses. I think if the arbitration was seated in DC and the enforcement is also happening in DC, to a certain extent, you're making the court's job a little bit easier when it comes to evaluating the strength of either or both of these grounds. I think, we've all been involved in cases where the court here has to look at whether there is a violation of the law of the seat in another jurisdiction. And the courts here are very sophisticated, and they generally, in my experience, do a very good job of doing that. But there is oftentimes the risk that something will get lost in translation. But if the seat of the arbitration is DC and enforcement is also happening in DC, then I think the risk of that loss in translation is probably narrowed. But then just very quickly on the question of set aside, Article 5.1e provides that the court may decline enforcement where an award has not yet become binding on the parties or has been set aside by a competent authority of the country in which or under the law of which the award was made. And I think here too, what I said a moment ago about the distance and the potential for loss in translation also narrows. So to the extent that the court thinks that it is to the extent that the court is satisfied that the set aside does not violate public policy under the Termo Rio precedent of the DC Circuit, then I think the court will be much more likely to decline enforcement on the basis of this article.
First point about personal jurisdiction. Would the fact that a party participated in an arbitration seated in Washington, D.C., be sufficient minimum contacts to establish personal jurisdiction over that party in an action to recognize the award as a U.S. judgment?
I don't know if it would be sufficient in and of itself to get to that finding, but I do think it would certainly help if you had that. Particularly, I would suggest if you had the hearing physically in DC, if the underlying relationship between the parties in some way, whether contractual or a business relationship, if in some way it clearly involved DC and necessitated the defendant coming to DC as part of that business relationship before the dispute began.
The advantage to me, if that issue were ever decided, and if you go back to what is the point of minimum contacts, well, minimum contacts was always designed to test whether it was reasonable for a party to expect to be hailed into court. I mean, there should be an argument somewhere that if you participate in and chose DC as a seat of arbitration, you participated in an arbitration there, particularly if you came and attended a physical hearing in DC, it would not be unreasonable to hold that that party should expect to be hailed into court for purposes of a recognition action. It would be specific jurisdiction, perhaps, not general jurisdiction. But if that argument were sustained by a court, and that were the rule, the effect would be DC courts could issue a judgment recognizing the award, and that judgment would be entitled under the Constitution to full faith and credit in other courts. So in that sense, again, then this is a plug potentially for DC as a seat. In that sense, DC could offer a gateway to the United States now, or any jurisdiction really in the United States where some court had held that participating in an arbitration was sufficient to establish personal jurisdiction. And if there's no contrary precedent in DC, it might be a good place to try it. But I'm going to circle back now to the question of vacature. And I know, Jonathan, you kind of looked at how DC compares with other jurisdictions on this question of when will the courts intervene and vacate an award. And would you share with us what you learned?
Sure. Well, we all just really jumped right into it, huh? Let me say up front, pleasure to be here. Nice to be with colleagues old and new. Thank you to Washington Arbitration Week. But yeah, if we just got right after it with the comments. All right. For a comparative view, I'm going to offer some comments on 3 jurisdictions, but I'll start as a framing concept with 2 words: award finality. Our party is going to get the benefit of what they bargained for: a neutral, final, binding, let's say hypothetically efficient process as an alternative to national court litigation. Now, a party's perspective could change on that if they lose in the arbitration. Then suddenly they may have keen interest in a quite active judicial review of the award. But for now, I think as a basic starting point, we can agree parties generally are looking to arbitration as well, at least award enforcement as a expedited, fairly limited review process to confirm or set aside an award. Now, in recent years, we've seen some noteworthy cases across a few jurisdictions on this issue, reflecting varying degrees of adherence to that starting principle. This includes cases involving a public policy challenge, Nicolle alluded to it earlier, public policy challenge to an award where there are allegations of corruption. This highlights how the choice of seat at the outset could ultimately impact where the parties wind up and what the final result is when you get to the end of the enforcement process. I'm going to address cases from France, the UK, and of course here in DC. I'll note at the outset, I'm not a practitioner of French or UK law. Did not stay at a Holiday Inn Express last night, but I will venture the following. First, in France, in Belkan v. Kyrgyzstan, the case drew attention in 2017 when the Paris Court of Appeal set aside an UNCITRAL award due to corruption based on an expansive review of evidence that hadn't even been before the arbitral tribunal. It included new evidence that the claimant had established a bank for the sole purpose of money laundering, he'd procured the investment through bribery, and he had facilitated his misconduct through a personal relationship with the president's son. The French Court of Cassation affirmed that ruling in 2022, holding that an award can be set aside where there are serious, precise, and concordant indications of corruption. Now, that was an investment case, treaty case, and some of the audience may be thinking maybe these corruption issues are unique to those types of cases and have no application in the commercial context. But in just the weeks after and then years after the Belkan decision, the French courts grappled with a few additional cases in the ICC context, the commercial context, dealing with allegations of corruption in the arbitration. In these cases, much like in Belkan, the courts engaged in a de novo review of prior evidence, and they also considered evidence that had not been before the arbitral tribunal. One of these cases was a case involving Gabon, involving disputed payments under a public works contract. The court considered evidence that had been before the tribunal, including a Louis Vuitton bag stuffed with cash. The court also considered other evidence that hadn't been before the tribunal and set aside the award. In another case, Alexander Brothers v. Alstom, Court of Appeals again considered award evidence that had been before the tribunal, evidence that had not been before the tribunal, and based on indicators of red flags of corruption, set aside that award. In Alstom, this eventually went to the Court of Cassation again, and the court there upheld its standard that a court can look for these serious indicators of corruption. But also, in this case, actually remanded it back to the Versailles Court of Appeals, which took a close look at the underlying award and the evidence, and ultimately decided that the indicators of corruption were not serious enough to warrant setting aside the award. So, does the final outcome in Alstom, where the award was actually upheld, indicate maybe a swinging of the pendulum in France, where we had Belkan and a very active review of evidence before the tribunal and not before the tribunal? In Alstom, you wind up where the award ultimately is enforced. My understanding is that the basic standard of review still stands as the Court of Cassation established. So there's still this prospect out there that a French court on reviewing an award is going to look for these serious indicators of corruption. It's going to perform a de novo review. It may consider evidence that was not before the tribunal. And I think that in general, France continues to be seen as having a more expansive judicial review process. And that may factor into why, as Simon noted, France has been in the decline in terms of the parties choosing France as the go-to seat of arbitration. All right, let's turn to the UK. In 2020, the Commercial Court in London upheld the very same Alstom award. So that case wound up, there were enforcement battles in the UK, in France, I think in Switzerland, multiple jurisdictional battle. The UK court considered that it could reopen, in comparison to the French courts, could reopen the issue of illegality only in exceptional circumstances, that it could not hear new evidence pertaining to allegations, and in fact, allegations of corruption. In fact, it would be an abusive process for the court to go down that road. Just a few years later, in 2023, very notable case by the Commercial Court again, setting aside an $11 billion award. This is in the Nigeria v. Process and Industrial Developments case. The court set aside the award on the basis that the award had been obtained through fraud and was a violation of public policy. Notable case, notable facts, including what happened within the arbitration itself. The English court found serious irregularities in the arbitration included the claimant had knowingly submitted false evidence to the tribunal. The claimant had bribed a public official in order to procure the contract at issue. The claimant continued bribing that official over the course of arbitration to buy that person's silence. And the claimant had secretly obtained privileged materials from the state side, state's defense, and held it and used it to their advantage in secret. So based on those findings, among others, the UK court said The tribunal didn't even know about this because the court was considering evidence that had not been before the tribunal. Tribunal didn't even know about any of this. There was a question about whether the tribunal should have known about it and how, to what extent they performed their duties. Court found the tribunal didn't know, and the arbitration itself was a shell that got nowhere near the truth. So, Alstom, UK court, Nigeria, the court sets it aside. But before we start thinking that the Nigeria case was some, herald of a more interventionist role by UK courts, we see just recently the Arbitration Act of 2025 that went into effect just at the beginning of August. And actually, the Nigeria case was considered as part of the debate in the formulation of this new arbitration law in the UK and whether the law itself should speak to issues of corruption or what should it say about judicial review. But one of the notable amendments under the Arbitration Act of 2025 is that it includes a limit on grounds and evidence that can be used in court to challenge a tribunal's jurisdiction. So a party generally can't raise a jurisdictional objection before the court. Party can't rely on evidence before the court if it hadn't raised that evidence or that objection before the tribunal itself. And the court is not supposed to be in a position where it rehears evidence that was before the tribunal. So on balance, few interesting cases, but it seems, including with the passage of the more recent arbitration law, that the UK will maintain a more limited deferential approach to the review of arbitral. All right, that's 2 out of 3. I have to talk about DC for a couple minutes. So I'm going to address the case of Rutas de Lima, the Metropolitan Municipality of Lima, a case that actually multiple people up here have touched at one point in time or other over the years. This involves a concession contract to build, improve, and operate a series of toll roads in Peru. Rutas, the claimant, brought 2 UNCITRAL arbitrations. They were seated in DC, so it was a concession contract with a sovereign where the agreement in advance was that the arbitration would be seated in DC. And the arbitrations alleged that Lima had failed to make certain payments that were owed under the contracts. Lima argued in both arbitrations that the contract had actually been procured by fraud, by corruption by Rutas's parent entity, Odebrecht, which had been ensnared in a corruption, like basically a global corruption scandal that touched various jurisdictions, including but not limited to Peru. But the tribunals in both of those arbitrations rejected the corruption allegations. They rejected the defense, ruling in detailed, reasoned decisions that there wasn't evidence of a quid pro quo. That even if there may have been certain improper payments, even if in other contexts and cases Odebrecht had admitted to corruption, there was nothing to tie any corruption to the particular contracts at issue. Lima sought to set aside both awards in DC on essentially the same grounds. They came and they argued the same corruption issues. They argued nearly all the same corruption evidence, though they did suggest that maybe they had some new evidence the court should consider that had not been before the tribunal. The court decision, I have to say, is a great read. You should read it. And it's a good example of the limited scope of judicial review of awards in DC under the Federal Arbitration Act and also under the New York Convention. The court, I think it's somewhere around page 1 or page 2, describes this series of arbitrations, multiple arbitrations where Lima is arguing corruption. Then Lima comes to DC court and argues the same issues of corruption. The court describes this as the litigation equivalent of Groundhog Day, with a formal citation and a footnote to the 1993 movie starring Bill Murray, where he's trapped in this cycle where he's waking up in the same town on the same day and has to live through the same experience over and over and over again. In other colorful footnotes, the court draws a comparison of a sports agent storyline between the movie Jerry Maguire and the HBO series Ballers. The court thinks Ballers was a more apt comparison. Provides an explanation of the billiards expression, them's the breaks, and then explain that a zeptosecond is a trillionth of a billionth of a second. Color aside, the decision is firmly grounded in the Federal Arbitration Act and the fundamentals of expedited, limited judicial review. The court performed a careful assessment of the reasoning of both tribunals and essentially found that the arbitrators had done their jobs. They had considered the evidence, They had provided their decision in a reasoned manner. They addressed what was relevant, what wasn't, and the arbitrators reached their conclusion, and they did their job. The court denied that there was a public policy basis to set aside the award on the basis that Lima wasn't arguing the award itself had been procured corruptly or through fraud. Lima was arguing that the underlying contracts had been procured through corruption. And what the court said, the dividing line the court found was, in this situation, that's an issue for the arbitrators to decide. If the contract was procured corruptly, the court on review is to determine, was the award procured through corruption? And then the tribunal ruled there was no evidence that the awards had been procured through fraud, or that Lima had been denied a fair hearing, or that the tribunals hadn't properly allowed the parties opportunity to put in and consider it. So the court says, at bottom, Lima asked the court to chuck out 2 arbitral awards that Rutas won fair and square. The court will not upend well-settled law under the FAA by rehearing a claim 2 tribunals have independently rejected. And that decision was just recently affirmed by the DC Circuit this summer, I think in June. Court there underscoring the national U.S. policy favoring arbitration and the limited grounds for judicial review through an expedited process as a matter of law under the FAA. So that's my survey of the landscape of corruption cases across a few jurisdictions. A few quick takeaways from this. Where does it leave us? Can you take these particular cases, put them on a graph somewhere, and chart like a straight line extrapolation to say, okay, France good, UK better, DC best? I think we're saying DC is best here for a range of reasons, but I don't think you can draw a definitive conclusion from just a handful of cases. And this is still full of room of lawyers, and we will always argue that there's room for argument. And I think that these cases do, in many circumstances, turn on the circumstances of the arbitration that were presented. And when you're dealing with a mega billion-dollar dispute, like in the Nigeria case, parties inevitably are going to go and keep arguing for as long as they can and as long as they have to. And that's almost certainly not going to stop in the arbitration. You're going to wind up in an extended battle in the enforcement context as well. That Nigeria case involved a particularly egregious set of circumstances. It didn't set the UK off in some new direction of interventionist, activist courts. The recently enacted law kind of confirms where UK sits in terms of a fairly limited judicial review of awards. In Rutas, the court maintained it wasn't its job to redo what the arbitrators had done, but at the same time, the court took a giant magnifying glass to the entire record of the proceeding. You can have set aside or enforcement motions in DC court that are heard in a hearing totaling 30 minutes at most, where each party gets 10 or 15 minutes aside. In that case, the court conducted multiple hearings, hours long, grilled the lawyers from both sides on issues of fact and law and evidence. So ultimately respecting what the arbitrators had done, but it was not by any means a cursory review of how the tribunals got where they got. On the other hand, for Bellicon, as an international lawyer practicing in DC, I've seen concrete consequences. I know of parties and counsel who have argued to tribunals in arbitrations seated in France. You should tread carefully here. You should carefully reason what you're going to do, because your award is going to be subject to very careful, close review by activist, interventionist, Parisian courts. I've at the same time seen parties shy away from using Paris as a seat of arbitration where they otherwise might have, because now there's this case law out there that says if you have an award, you might wind up litigating for years in France, and the courts might be examining evidence that wasn't even before the tribunal. I think, it's pretty clear that sophisticated parties and counsel are going to continue taking these types of cases into account when assessing the importance of the seat, and, including with respect to this key issue of finality of the award.
Thank you. And I'm now going to firmly resist the temptation to get my the other panelists on the record about whether allegations of corruption should amount to the litigation equivalent of Groundhog Day, and instead move forward to one of the other reasons parties choose a seat. And Those are the practical aspects. We've gone for about 3/4 of an hour now on lofty questions about vacature and corruption and who should hear them. And it's gotten to that point in the conference where everybody's heads are down, looking in the phones or catching up on the morning nap. So I'm going to try to make it a little less theoretical and a little more practical. Now, we as lawyers all know that there's a difference between the legal seat of an arbitration and where you hold the hearing. But it's my thought that in the client's mind, at a time of drafting a contract, that the choice of seat, the client often visualize the choice of seat as the place where they are going to have to go if an arbitration is needed. And it may be the case that if that happens, there may be practical reasons for holding it elsewhere. But in the client's mind, the choice of seat is this is where we are going to go to have justice. And so I just want to talk a bit about DC as a the practical aspects of holding an arbitration in DC. And let's maybe in the answers differentiate a little between commercial and investor state arbitration. But let me, Nicolle, what has your experience been with the ease of entry for witnesses? And does the current political environment in your practice have things changed?
We're already seeing witnesses concerned about getting into the United States, getting cleared and all that. And you have to factor that in when contemplating having the hearing here. There are certainly already circumstances where some witnesses can't come and we have to do that witness remotely. So it is another factor if you have your key witnesses that are going to really struggle to get into the United States or don't want to come to the United States because of travel challenges and having to cross the border, that may not be the right location.
I can jump on that as well. I'm also seeing it from tribunals. Tribunals saying, can we reconsider where this arbitration should be held? Unwillingness, one negative experience for an arbitrator trying to come into the US will lead to them being unwilling to return and to proposing London or Paris or somewhere that they feel is equally as good facilities wise, equally as easy for everyone to get to. In many cases for big law firms, also places where everybody has an office and just a bit easier and nicer for everybody. And when it's coming from the tribunal rather than from the need of a particular witness or maybe a couple of witnesses, obviously very hard for the parties to push back too much on that. So that's what I'm observing some change as well.
And what about in the context if it's an ICSID arbitration? Does the fact that the World Bank has the capacity to, facilitate entry for a proceeding, at least I believe it does. Looking out at Meg for confirmation, thank you. But my question is, does that make a difference? Do parties and arbitrators feel better about entering the US when they do so under the auspices of ICSID than for a purely commercial arbitration? I'd say the answer to that.
Anyone, but
I think in a sense, there's always a certain inertia with these things, right? I do think that certainly for many years, DC was a favored place to hold hearings in investment cases. And I think, although I haven't seen statistics recently, but I think just anecdotally, that probably continues to be the case even now. And so unless you do get into a situation where people are having a more difficult time coming because of visa reasons, even though I can personally attest to the fact that ICSID has been tremendously helpful in facilitating visas for individuals in active cases, I expect that will probably continue, and hopefully it does, because I do think that DC, certainly for investment cases, is very difficult to beat unless you have some very strong logistical countervailing consideration.
ICSID offers, in addition to all the advantages with respect to award enforcement, offers the advantage here in DC of a solid infrastructure for the holding of physical hearings. I've had great experience at ICSID. I have had great experience in The Hague at the Peace Palace. You should argue a case there if you can. I am more recently dealing with some commercial cases under different sets of rules administered by different institutions, which are basically telling the parties, good luck, go find your hearing venue, go find your court reporters, go find your translators. Whereas my experience in the past with the ICSID cases in particular, but other investment treaty cases, is that the administering institution does a good job of taking care of those things for the parties. Whereas on the commercial side of things, my experience now is that the parties are left more to their own devices. So I think that the advantage of ICSID having a dedicated hearing facility is certainly a great thing.
Just to give a plug for the fact that those facilities are also available for other cases as well. We're unusual at Three Crowns in that we don't have an office in New York and we don't have any other offices in the US outside DC. So we'll actually have cases under New York law seated in New York. And we will agree with the other side to relocate it to DC and have the hearing. We did that just last week. That went ahead at ICSID's facility. So it is an option for firms who ultimately, when push comes to shove, traveling up to New York is an unnecessary inconvenience when you could just do it here.
Now, are the availability of ICSID's hearing facilities limited to cases where there's a sovereign or state-owned enterprise, or could you do this with the purely commercial arbitration?
I believe the latter, and from my experience.
But, assuming that's the case, that is a huge plus in favor of DC. I imagine the hearing rooms are very booked at ICSID, so finding a slot. But you and Jonathan went to right where I was going to go to next is hearing facilities. Each city, I think at the outset, Ian remarked how cities compete for arbitrations, and one way is to have hearing centers. And someone recently opened an arbitration center in Frankfurt, and I had, heard for years now that Georgetown was going to open some sort of hearing facility. And Csaba, you mentioned it was probably like the Georgetown boathouse. It's been in the process of being open since 2004. So I don't know if there's anybody here who has heard the latest rumors on Georgetown and hearing facilities, but if someone knows something is in the audience, they're invited to speak up. All right, then I suggest it's like you can comment on the boathouse.
Sorry, well, no, I mean the boathouse is a sore point in my life, but I think in addition to the hearing facility, DC does have tremendous sort of what I would consider a community of providers for things like printing, photocopying. We've all been in hearings where, you have to get last minute witness bundles done, and you have to produce 10 binders tabbed with the tabs labeled, everything printed properly, or, slide decks for the closing presentation that are ready at 5 a.m. and they have to be, in the hands of the tribunal by 9 a.m. And actually, that can be a hugely difficult thing to get done if you don't have people in the city who know how to do it and can get it done quickly and well. That's never been an issue for us here in DC. We have fantastic providers, but it has been a significant challenge in many other parts of the world. Where perhaps, the culture is just is not very used to having those sorts of last minute requests with an expectation of excellence joined to it. So
yeah, on that front, I had a hearing in Kansas City in April, and they are not used to working at 5 a.m. You need on a Sunday with opening argument at 9 a.m. on a Monday morning. So it's a huge factor, and add to that other things like the availability of translators and interpreters. And I just recently had a really challenging experience with a reasonably obscure language for a few witnesses, and there really were only a couple of people in the U.S. who could assist with that particular translation, and they were here in DC. Makes life a lot easier.
Csaba, your and Simon remarks make me think back to one of my very first arbitrations and trying to print binders in Paris, and what a nightmare it was. I'm not sure anything's changed in Paris. You may be able to go out to dinner better in Paris, but if you need to print binders, God help you. which, you know, I will throw in one more plug for DC in the sort of practical aspects of an arbitration. And I think it's underestimated. It's such a great city for client management. If you have a client in town for hearings, you can get them, assuming you have the connections, but you can get them tours of the United States Congress. You can get them a tour of the White House. Now, that may be a little bit more complicated now, but we have done all of these things. So when you need to sit down and work with a witness and you've got people who need something to do, DC offers a host of things that the client is often eager to go do and let you work. And I think as every practical lawyer in here recognizes the enormous value of that. So with that said, and probably filmed for posterity and any client who may look to hire me. Yes, a Segway tour. We did that one. You did that too? All right, then I will just, I'm going to just see if any of my panelists have any closing remarks they'd like to make before opening it up to the floor for questions.
Just had one addendum in response to the question that Csaba put to me earlier about the whether there's much diversity between choice of law and choice of seat. My addendum is to say that I do observe in contracts where there's the host state is a party or a state-owned entity is a party, that they are very reluctant to give up their own domestic law as being the governing law of the contract. And that's normally something that the investor has to cave on. Whereas the seat of the arbitration, which is at that moment in time being considered like deciding where you're going to have your burial plot, you know, it's so irrelevant because there's never going to be a dispute, is something that everyone's thought that the host state is quite willing to cave on. And willing and don't even see it as much of a give to agree to London or to New York as a recognized center. So I have a lot of cases, which lead to these interpretation challenges, where you have a foreign law being applicable, but it's being argued in London, it's being argued in Paris, it's being argued in New York.
Very interesting.
All right, do we have any questions from the floor? Yes. Man, I saw your hand raised and so does anyone want to take the question? And could you repeat it into the mic?
So the question was whether we've seen any cases involving the debtor having assets in DC and whether that has featured in, I guess, in the choice of the seat. You know, I really haven't. I mean, most of ours, especially involving foreign states, enforcement starts here for recognizing the award, and then enforcement of the award of the judgment takes place elsewhere, often in New York, maybe in California, where there's some assets. I'm trying to. There has been some in DC, like attempts to attach property that like a state has it's in the process of selling, so it becomes commercial and not diplomatic property at the moment, something like that. So we've seen that with states, but it's not very successful because of the restraint on attaching diplomatic property. I don't know if anyone has experience like bank accounts in DC. Nothing.
Similar reaction. I think more often the DC courts are adjudicating these sovereign immunity issues on the sovereign cases. They're deciding those elements, which are then going to have implication in New York or elsewhere, where the assets sit, or where the money is being wired through and out, and that presents a whole interesting set of issues as to when and where you can attach. But generally, my experience is that we're not fighting over assets here in DC.
Yeah, I think this really kind of harkens back to one of our first questions we dealt with, why DC, and then the difference between commercial and investor state arbitration. There's Simon's remark that New York is really associated with commercial arbitration, and DC is just simply there's not necessarily a lot of companies located here and with assets here. But that's also what prompted us, I think, to think about whether seating it here could provide an entry point for enforcement throughout the United States as a whole. Let me just, we've wrapped up to 1 hour. I know it's designated for 1:15, but I also know from your perspective, you want to have the coffee and talk with each other more than you want to sit and listen to more. The human mind just can't take more than 1 hour of people talking to them. It's something I've found true. That's why coffee breaks and arbitrations are about every 1.5 hours. So any final questions from the floor before we break for coffee? Yes.
First question. The number of contracts choosing Hong Kong as a choice seat for arbitration is diminishing, and the number of contracts with Singapore is going up. In order to understand why, just because of the Chinese influence.
I think you have hit the nail on the head. I think a relevant factor for international arbitration users choosing seat is geopolitical stability of the seat. That's why London remains very popular, New York remains very popular. Hong Kong remains a seat of choice for users in the region, in China in particular. Shenzhen the same, just across the way. But in my experience, clients are now increasingly concerned about political influence in the decisions of the courts. You may have observed in the Hong Kong courts a lot of the sort of former British, Australian, New Zealand judges who were sitting on the Hong Kong courts have resigned. Without necessarily expressly saying why, just, pursuing other directions. It's reasonably obvious that that's because they do feel that there is a degree of influence in their decision-making that is inconsistent with their ethics and values. And so what I'm observing now is that if you are looking for a seat in the region, clients are increasingly comfortable with Singapore. Singapore has an ever-growing body of domestic jurisprudence and expertise of its courts in arbitration matters, and it's becoming increasingly the seat of choice in the region. Three Crowns has also opened an office there, which is consistent, I think, with the direction of travel of the region. We opened an office there just a couple of years back, and in this recent Queen Mary survey, Singapore is now level pegging with Hong Kong. They were each identified by 31% of users as being in their top 5. And that is a definite shift in the last 5 to 10 years.
Kayla.
Decisions that are not backed by reason opinion out of the United States subject to criticisms that have been leveled against other jurisdictions in terms of instability of judicial jurisprudence.
Let me just repeat that for the mic. The question was, does the Supreme Court's use of the shadow docket to issue unreasoned decisions raise concerns about the political stability in Washington, D.C. and its future as a seat of arbitration?
I mean, it's a good question. I don't think we've seen the use of the shadow docket in cases involving the arbitration space right now yet. But if you need to come to a seat for emergency relief, right? Injunctive relief or provisional measures being enforced through a court, that has the potential to escalate, especially, potentially involving a sovereign. It has the potential to escalate through injunctions quickly to the Court of Appeals and then potentially through an unreasoned decision. It just seems a little bit remote compared to the very slow process and detailed decisions we're kind of used to getting in these arbitration cases. So I don't think that concern should factor in just yet.
Well, it was a version of Gaila's question that I was going to use as a segue for next year's Washington Arbitration Week, so that we might have more information on what, how political stability or perceived political instability influences the choice of seat, and whether Washington, D.C., how it impacts Washington, D.C. as a seat for future arbitrations. So I'll just leave that thought with all of you, and hope to see you again next year at Washington Arbitration Week and talk about that subject and others. But first of all, finally, please thank my co-panelists for today and all their work.